VP of Business Development, Compliance Officer for PACE, and will be your moderator today. As we prepare to begin, there are a few housekeeping items I'd like to inform you of. Number one, this webinar is being recorded. Secondly, all lines are muted to avoid background noise. Thirdly, presentation, so feel free to type any into the chat box located in the lower right-hand corner of your screen. We will attempt to answer any questions today, all questions today, and those we don't get to, we'll respond via email. I'd like to now introduce our presenters. Terrace Gonzalez is a partner at Caton, Muchin, Rosenman LLP. Eli Schwartz is Director of Strategic Accounts at Lead ID. And Michael Gooding is Deputy Counsel at Fidelity Life eFinancial. I'll kick us off today by opening with a high-level overview and update on PACE's appeal on the FCC's declaratory ruling. In February of 2016, PACE filed an opening brief in its appellant challenge to the FCC's recent order interpreting the TCPA. Congress passed the TCPA to restrict calls to cellular and other specific telephone lines made using an ATDS or an automatic telephone dialing system. That system specializes in automatically generating and dialing thousands of random and sequential numbers, often to deliver unwanted pre-recorded messages. Congress did not, however, prohibit all forms of computer-assisted dialing. In that challenged order, the Commission misinterpreted this focus law and concluded that it applied to a broad array of common beneficial dialing equipment. The Commission's order threatened to subject even routine phone calls or text messages from smartphones and ordinary office phones to liability under the TCPA. This unlawful interpretation of the TCPA affects even modern organizations that make phone calls or send text messages. For example, schools that send out safety alerts, charities that solicit contributions, and businesses that send out appointment reminders by phone. That result is contrary to Congress's intent, the First Amendment, and common sense. Separately, the Commission imposed liability on a caller if it dials a consumer who agreed to be contacted but unexpectedly reaches someone else because the consumer's phone number has been reassigned. And to the detriment of callers and consumers alike, the Commission prevented callers from relying on any centralized system for the orderly intake and processing of consumers' requests to revoke consent to receive calls. PACE feels that these misguided rulings jeopardize desirable communications that Congress never intended to restrict, and they will encourage wasteful class actions, which we'll talk about a little bit later, seeking crippling statutory penalties. In this brief, PACE, along with 9 other businesses and associations, has asked the U.S. Court of Appeals for the D.C. Circuit to set aside these unlawful aspects of the Commission's order. The Commission's response brief was filed in January of 2016, and the reply brief in support of PACE's challenge was filed on February 16th of 2016. So join PACE at the 2016 TCPA Washington Summit this September 18th through the 20th to hear details on the current state of the PACE appeal with PACE's General Counsel Michelle Schuster of McMurray, Peterson & Schuster, and Shai Dvorsky of Jones Day Law Firm, along with Mark Stone of the FCC's Deputy Chief of Consumer and Governmental Affairs Bureau. Now I'm going to turn it over to Eli, who's going to go through the agenda and then present.
Thanks, Marjorie, and thank you to everyone who dialed in to join us today. Before we jump in and get started, I'd just like to thank PACE for hosting the webinar today, and also a huge thanks to Bob Traylor, who I think is on the line, for making the connection between our companies. I thought it might be helpful to give a little bit of context to the audience as to why Lead ID is involved in hosting today and what we have planned on the agenda. So for those of you that haven't heard of us before, we've built a technology platform that witnesses consumer behavior online. And over the past 3 years, we've helped marketers and legal and compliance teams defend against TCPA complaints and lawsuits by proving express written consent. In our experience, there are generally two big compliance gaps that most companies who are placing phone calls and texts to their prospective customers face. The first is actually ensuring that they have the appropriate express written consent before they place a call. And then the second is having a way to prove that consent and prove that consent persuasively after a call is made. So our focus is squarely on consumer consent, and this was actually the impetus for today's webinar. Thanks again to the introduction by Bob Traylor. I met Marjorie and the folks at PACE a couple of months ago down in Orlando at the conference, and it was clear that this issue of consumer consent has become a hot button topic among the PACE membership. So we thought the timing would be right to share some of our experience and best practices with the group. So the plan for today, we've got a great lineup of content. I'm personally excited to hear and learn from Terry and Michael. They each bring a pretty unique perspective. Terry having extensive experience as a litigator fighting TCPA complaints, and then Michael having served as the general counsel for a large insurance carrier and taking on the responsibility of building out a TCPA compliance program. And every time I talk to these guys, I learn something new. So I'm going to go ahead and get myself out of the way now, and I'll hand it over to Terry, who will kick us off with an overview on TCPA and some of the risks that we should all be aware of. And then Michael will come back in and share some of his experiences and best practices with building out an internal compliance program. And I'll check back in towards the end to share a little bit more on how Lead ID's technology fits into all of this. So with that, Terry, I'll let you take it away from here.
Great. Thanks very much, Eli and Marjorie, for the introductions, and thanks for everybody who took time to join us today. I think, as we all know, there has been an incredible increase in the amount of TCPA lawsuits that have been filed over the past several years. According to ACA, there was 3,700 lawsuits filed in 2015 asserting claims under the TCPA. That represented a 45% increase over 2014, and the 8th year in a row where the number of TCPA lawsuits increased from the preceding year. In 2015, about 23% of those lawsuits were filed as putative class actions. And as you can see on the screen, 2016 is not going to disappoint in the number of TCPA lawsuits. There has just been an extraordinary increase even in 16 over 2015. These lawsuits that are walking in the door almost on a daily basis are not just focused at the obvious targets of large corporations. Many of these lawsuits are filed against small to medium-sized companies who may inadvertently or unwittingly violate the Telephone Consumer Protection Act. The Act, as you all know, has mandatory statutory damages of $500 per call, or $1,500 per violation if the violation is proven to be willful. Those statutory damages give rise to very, very large numbers against big companies and small companies. There was a widely publicized judgment out of the district court in New Jersey of a small roofing company who was hit with a $22 million judgment for alleged violations of the TCPA. These numbers and this proliferation is driven by a number of things, none the least of which is advertising by the plaintiffs. And that advertising comes in a number of different ways. We've given some examples here on the screen for you, but there's even apps out there today in which a consumer can collect information regarding an alleged TCPA violation and then submit that information to a plaintiff's law firm who can then file a lawsuit on their behalf. And there's some interesting background on some of these apps. In fact, the one in the middle block called Get Cash is subject to some litigation between the law firm that runs that particular app and one of its former partners. In their separation, that was less than acrimonious and led to litigation, and the exiting partner filed a counterclaim that raised some very interesting information regarding how these apps are used to collect and identify new potential plaintiffs to file individuals or class action lawsuits. But at the end of the day, this type of advertising and this type of notice is continuing to drive the litigation that we're all seeing in this space. And so that leaves a lot of companies wondering, of course, not if they're going to be sued or whether they're going to be sued, but it's really a matter of when. And in my practice, defending companies who have been served with a lawsuit or served with an attorney demand, many of these companies are doing it right, and yet they are still being forced to defend these claims. And when these companies are forced to defend these claims, sometimes the class settlements can be very, very high. We all know about the Capital One settlement for $75 million, but there's been many others where the settlement in dollars have been in the tens of millions of dollars. HSBC for $39 million, JP Morgan Chase for $34 million, and there's many other examples like that that give us all real pause as to, you know, what should we be doing as best practices to mitigate our risks with respect to this fairly oppressive statute. And it's clear that the statutory damages and the high exposure of these cases are reasons for the continued increase in TCPA litigation. But one of the reasons that these lawsuits continue to come in so frequently is the ease in which they can be brought. It's not a difficult lawsuit to bring. It's not a complicated statute where there are many elements that must be met. The Act simply says that it's unlawful for any person within the United States to make a call other than one made for emergency purposes or with the prior express consent of the called party, using an automatic telephone dialing system or an artificial or pre-recorded voice to any telephone number assigned to a cellular telephone service or a service for which the called party is charged for the call. So for a plaintiff to file a lawsuit and get to discovery, which can be very expensive for a company, the plaintiff merely needs to allege that it received a call from an ATDS without giving prior express consent on a cellular telephone for which they were charged for the call. Now, that pleading standard, being as minimal as it is, allows the plaintiff's bar to file these lawsuits, get past what us lawyers refer to the pleading stage, i.e. that the complaint states a cause of action, and to get into discovery where they can force the company to start defending the claim, proving that its system does not qualify as an ATDS and or proving that it had a consent to dial the plaintiff and or the class members of the putative class. The Supreme Court recently added maybe a little extra requirement in the pleading standard. In May of this year, in a case called Spokio v. Robbins, the United States Supreme Court ruled that the plaintiff must do more than just allege a violation of the act or of the statute. That in order to confer jurisdiction in a federal court, a plaintiff must actually allege that they were harmed by the conduct at issue. And that when they allege or claim that they were harmed, they must be able to articulate it in a concrete and particularized way such that the court has jurisdiction to hear the claim. Now, it may sound wonderful that there is this additional burden of harm, but as you might guess, it's a low burden or a low hurdle. In my opinion, that I think the Spokio ruling will have a greater impact with respect to class litigation as opposed to individual litigation. But we will see. I think we will continue to see litigation regarding the articulation of actual harm received from a violation of the TCPA in the coming months. So we know it's not going to go away, and we know that businesses of all sizes and shapes are going to be subject to this type of litigation. So what types of defenses does a company have to TCPA litigation? Well, we're going to hear about one of the most important from Michael, which is the compliance program behind it. But when you get to the litigation stages, one of the defenses that defense counsel like myself had been using to limit the class action litigation is settlement. We all know that early resolution or an early settlement can very often limit the company's exposure, both with respect to settlement amounts, judgment amounts, and attorney's fees. One strategy in a class action case, such as a TCPA case, would be to issue a settlement offer to the named class representative. And if you offer the class representative full relief of their individual claim, many courts have held that that would moot or eliminate the class claims. So it was a strategy of the defense bar, particularly in these TCPA cases where you could easily quantify the damage to the named class member, to issue them a settlement offer early on in the case in the hopes of eliminating the class claims. Unfortunately, in October of this year, the Supreme Court ruled again, and not in favor of allowing that. In Campbell Ewald versus Jose Gomez, the Supreme Court ruled that an unaccepted settlement offer of judgment, even if it fully satisfies the claims made by the class representative, does not moot the class claims, and thus does not eliminate the class exposure to the company. Now, the Supreme Court, being what it is, left open the issue of whether or not the defendant actually deposited the money with the plaintiff, whether that would moot the class claims. And that is an open issue that the Supreme Court left the lower courts to wrestle with. And like Spokio and the need to articulate concrete and particularized harm, Campbell Ewald left open the issue of whether you can move the class claims by depositing a settlement amount with the plaintiff. I think we'll see litigation on both of those issues in the coming months and in the coming years. But beyond those defenses, what are you truly left with when you look at these claims? You are really left with the definition that's provided for in the statute, and that is the system that you're using an automatic telephone dialing system, and do you have evidence of express consent to make the call? Well, as Marjorie told us, the FCC's recent order in 2015 greatly expanded the definition of an automatic telephone dialing system. The statute says it's equipment that has the capacity to store or produce telephone numbers to be called using a random sequential number generator. Well, the FCC expanded that definition to include not just present capacity, but future capacity. So if the system that you are currently using has the ability to be modified in some way so that in the future it could be modified to store and produce numbers to be called at a random and sequential number generator, then your system would qualify as an ATDS as defined by the FCC. And so many companies feel that if you're not hand dialing all 10 digits, you could be at risk of a court finding your system to qualify as an ATDS. With that, then you are left with consent. And do you have evidence of consent that is persuasive and that is going to convince the plaintiff's attorney and the court that you were allowed to use your dialing system to dial this potential customer or the putative class members? Now, how you marshal these defenses will depend on, without question, your company's compliance program. And the compliance program and the process to defend these cases begin with your organization of those things. And so I'm going to pause here and turn it over to Michael, who is going to speak to how you build a TCPA compliance program from the ground up.
Thanks, Terry, and thank Marjorie and Eli for the invitation, and thank you for all of the participants who dialed in. For the participants' perspective, or for you that are in companies, let me tell you, I know your pain. On the company side of things, Fidelity Life Association is a life insurance company that that we have a unique structure in that we have both the life insurance company, and then we have a call center. So, and we have a lead generating company. So we are not only the user and consumer of leads, but we are also producing the leads, and we're also selling the leads to unaffiliated third parties. We're relying on the leads we generate, and we're relying on leads from unaffiliated third parties as well. So we're kind of touching on every part of the lead generation and TCPA food chain. And compliance is, as you guys well know, is not as easy as you'd want it to be. Our organization, although the logo that we have says since 1896, we had a number of ownership structures, and we were recently owned in 2005 by Chase, and we spun out of Chase in 2005. So we spun out of Chase post the National Do Not Call Registry, post the Telemarketing Sales Rule Amendment, and right before the Junk Fax Prevention Act. But then the Do Not Call Improvement Act in 2008, and going forward, we've needed to be compliant with those laws going forward. Fidelity Life's compliance challenge, like I said, when you're participating in various links in the lead generation food chain, not only do we as an advertiser need to make sure that we have our compliance in check. As a lead producer, we need to make sure that we have a good compliance program, and we need to make sure that we're monitoring and making sure, to the extent that we can, that our third-party affiliates are also compliant as well. As far as what did we do from a compliance story? It really starts with that first bullet point where it talks about determine the process. What's required. So what is the TCPA? What are the requirements? What are all the rules and the administrative guidance that both the FCC and FTC has issued over time, and as well as the jurisprudence that Terry talked about as well. So it's as we all know, and part of the reason why we have this opportunity to not only talk about it, but as you as participants to continue to educate yourself, is that it's a changing, molding, modified, permutating area of the law that is seems to be a little bit, I know it's not a legal term, but it seems to be more squishy than other areas of compliance and law. But the bottom line is that at some point you need to determine, what is the law and what are the processes that you have that are internally, and do a gap analysis and figure out, well, what is it that you need to do? One of the things that we noticed is that our contracts, our lead forms, our publishers, our master publishing agreements, et cetera, there were some questions there as far as whether we could tighten up some of those agreements, not only making sure or specifically specifying the types of compliance that the publishers are agreeing to, but also from an indemnification standpoint, is that they, having them be liable, or from an indemnification standpoint, for not only their conduct, but also the conduct of their downstream or their affiliate network. So if you're dealing with aggregators, and your contract is at the aggregator level, I'd strongly recommend that you contract with them that specifies not only the various, specify that they are required to comply with the TCPA requirements, but also that they would indemnify for not only their actions, but as well as their network's actions. The next bullet point there is around tracking performance and auditing the internet forms. I don't know about all of the participants that are on today's call, but small, medium, and even large organizations, we all are strapped with limited resources. And thankfully, there's decent vendors that are out there to help with this. I mean, we used an outside vendor as well to help us build a compliance program. And then, like I said, is not only building it at the front end, not only making sure that you have express written consent, but you need to be able to demonstrate when the regulator comes knocking, you need to be able to demonstrate what you've done to monitor it, because they don't take too kindly to, well, we've transferred, arguments or statements that say, well, you've transferred it to this particular or that particular vendor, because ultimately they'll take the position that you can't transfer the liability. So you have a pretty significant monitoring responsibility as well. And then the last two bullet points there is just, you know, whatever's been implemented, whatever you find as a result of auditing, you know, whether you do that internally or whether you find a vendor partner to help you through that, obviously you need to respond to it. It's one thing to get information that, you know, you find out that either the URLs, either the links are bad, either you're using some affiliate that doesn't have the right express written consent language there. Maybe they don't even have consent language there. Bottom line is that there needs to be some kind of response to it. I know that there's some companies that are out there that use these vendors and they get reports back, and they don't, for whatever reason, follow up on those reports and you know, take affirmative actions to demonstrate compliance. So when you have the opportunity to go through the various steps, it is it's like that saying is like, how do you eat an elephant one bite at a time? And that's what TCPA compliance, at least for me, felt like, because there seems to be a lot of moving parts, and like I said, there seems to be administrative rulings and developing jurisprudence that just when you think you understand the scope of it, it kind of changes on you. But the bottom line is if you go through these processes and you demonstrate the audit and you've implemented the activities that come out of the audits, I think you generally are in a pretty good shape, you know, to roll it out, to share it with your general counsel, whether you have an internal general counsel or an external general counsel. But of course, you know, it won't take too long. And the next thing that you're going to be getting is that your general counsel is going to be either giving you a subpoena or some other legal document from the plaintiff's bar. And so now you're going to have your compliance program really tested. And as the bullet points here speak to is, first of all, before we talk about the response, as an advertiser, as a person, you know, I'm a consumer as well. To the extent that there are consumers who, through a marketer, has violated their rights as respect to the TCPA, they should be allowed and they should address the transgression and, if necessary, seek representation. Even though I'm an attorney for a corporation, and I've spent the majority of my professional life either as a defense lawyer or working for a corporation, I also understand that violations do occur, and nothing in my comments or in this presentation should be construed that, you know, plaintiffs should not seek representation if they're truly, you know, if there's marketers that are involved in violating the TCPA. What's really the issue is that the businesses need a solution, and one of the slides that Terry, one of the comments that, or one of the pieces of text that Terry had on his slide is talking about not only getting prior express written consent, but it needs to be persuasive proof. The program that we initially, the TCPA compliance program that we had, like most compliance programs, it's a work in progress. So we had, you know, good training for our business development representatives as well as our insurance agents. They had to pass tests internally. If they didn't, they had to retake the module. We have good, you know, training software around TCPA compliance for them. We keep our recordings for the required period of time. So not only, you know, do you have the front end, which is the express written consent, but we also have the recordings on the back end to demonstrate whether the consumer either did or did not clearly revoke that consent, and whether or not they should or should not have been put on the do not call list. So we had a lot of compliance mechanisms in place, including voice recognition software that were auditing calls in the background for trigger words such as "do not call me again" or "kill this lead, I got insurance from someplace else." So then, even if the call center didn't disposition that call correctly, there's notice that automatically gets sent to a supervisor that red flags that particular call, and it correctly dispositions the call independent of what the agent might have done, and it provides the agent and supervisor a training opportunity. But what we didn't have is demonstrated persuasive proof at the time of pre-litigation, and this is not meant to take any opportunity away from Terry when it comes to the quality defense representation that he and others at Catton provide clients. But from a corporation's perspective, it's so important to have a preventative compliance program in place that that I don't have to call Terry or his colleagues. So the compliance program stands on its own. We certainly will still get sued. We still have been sued, but the bottom line comes to, well, for us, what happened, or what was important to us, and what did we use to provide that persuasive proof? For us, it started with a relationship with Lead ID. Believe it or not, we approached Lead ID historically. Nothing about TCPA. It had more to do with analyzing our marketing spend, and we were taking a look at trying to do that optimization across lead generators. And out of that conversation was the TCPA developed a TCPA compliance conversation. That TCPA compliance conversation led us to the tool that Lead ID has, which is the visual playback tool. What I'm going to do is hopefully I can navigate this pointer correctly. And what this does is when a consumer is on the internet, says, hey, do you want an insurance quote for term life insurance? Click here. So they click there, they enter their contact information. Immediately below that, before they hit request quote or something like that, is the required TCPA consent language. What this information here does, behind the scenes, what Lead ID has, and Eli will talk a little bit about this when I turn it back over to him, is what Lead ID has is that they have various tags that they can have. Again, I'm sorry, Eli, if I'm not going to capture this right, but they have tags that are operating behind the scenes on the various lead generating landing pages. What we do as a company is we require any of our marketing affiliates to work with Lead ID. If they don't work with Lead ID, we terminate the relationship because the tags are crucial for ultimate TCPA compliance. What the visual playback does, it actually captures it's a playback of that consumer entering his or her TCPA consent information. So name, telephone number, and if there's any other data that they're putting in here. Now, from our perspective, and if I turn this over to a plaintiff's attorney's perspective, all they're seeing in these fields is asterisked out data. But say, for example, I'm the plaintiff's attorney and I've got this insurance company. I'm talking to this, annoying corporate attorney by the name of Michael Gooding at Fidelity Life, and he's claiming my client filled this out. So the plaintiff's attorney can come over here and enter in either John or Judy or whoever, Smith, and they can type in the name, and if that's the correct name, this box will turn green. If it's not the correct name, it won't turn green. So the plaintiff's attorney can demonstrate, can validate that his client or her client is the person that is filling out this lead landing page information. So when we're talking about persuasive proof, as far as what companies can provide to plaintiffs bar when they come knocking, whether it's a plaintiffs bar or even if it is a regulator, whether it's the FTC or FCC, and if the question is, what do you have to show that you have secured prior express written consent, the Lead ID TCPA solution has served us very well. I have a number of stories, but probably the most persuasive one is within the last year we received not previous complaint, not previous letter, not previous anything. The first notice of a TCPA related problem was a class action lawsuit that was filed in California, and contacted the plaintiff's attorney. I told him about our training program. I told him about lead ID. Sometimes the plaintiff's attorneys will actually want to see the visual playback. Sometimes the plaintiff's bar is getting used to lead ID. So if you say you have a relationship with them, sometimes that is enough, and they don't necessarily even need to see it. But with both the front end of the lead ID visual playback and on the back end of having the recording demonstrating that the visual playback shows that express written consent was given, the recordings show that it was never revoked, and then as a result of having that bookend compliance, you end up putting the plaintiff's attorney in a really difficult situation. Does he or she still go forward with whether it's on individual representation or class action representation and potentially expose him or herself to Rule 11 sanctions for pursuing the litigation in bad faith? Do they potentially pursue litigation when it appears that the defendant has a really good training program solution in place, or do they just move on? And in the particular case in the class action that was filed against us, they dismissed it without prejudice. Of course, we wish we would have had it with prejudice, but they dismissed it without prejudice without us having to pay 1 cent in defense fees. So that is very, very high level. I rushed through. I mean, you can't cover how to build a TCPA compliance program in a few minutes, but that is the component, the lead ID solution, and how it's been a very valuable tool in our TCPA compliance program. Terry, did you have any comments about, from your experience from a litigation standpoint, as far as how lead ID has worked on either facilitating a defense or pursuing litigation a little bit less tasteful for plaintiff's attorneys?
Sure, absolutely. I have used the visual playback in some of the cases I have handled as outside counsel, and in my opinion, and all of the comments I've shared today are my personal opinions and not those of Cat and Muchin, but in my opinion and in my experience, the visual playback is the kind of persuasive evidence that really does push back the plaintiff's bar. I have similar success stories like the one Michael shared against very sophisticated class action plaintiffs firms who first noticed with the company was the filing of a class action lawsuit, the sending them information regarding the lead ID and the visual playback, and having the lawsuit be dismissed without prejudice, or in some cases, I've paid a very nominal fee to get the dismissal with prejudice. Most recently, when I had an individual lawsuit, I sent a letter describing the visual playback, describing lead ID. I got a call from the plaintiff's attorney, and he said, "Hey, Terry, doesn't look like we'll be contesting consent on this one." So for me, when I present this evidence to a plaintiff's attorney pre-litigation or early on in litigation, or to a judge, the goal for me is to be persuasive such that they go away, that we can terminate the case as early and as inexpensively as we can. I, too, like Michael, I have spent years in-house, and I recognize that managing defense costs is the key to any client relationship. So we want these cases to end early. And what I find is that the consent that I get in some instances might be, for example, raw data on a spreadsheet, or maybe I'll get a screenshot from the company's computer system. Sometimes I get it summarized in an email, and I'm not quite sure how I present that to a judge or jury. When I think about the visual playback, it's not really like the difference between a movie and a good novel. It's kind of the difference between a movie and the fine print on a contract. And imagine presenting one versus the other before a judge or jury, and which one's going to capture and be more persuasive in saying, this is a case I don't want to pursue. So I have had similar experiences, as you did, Michael, with this particular solution. And I can't really speak to how it works. I have some sense. I think I'm know enough to be dangerous, but let me let the expert here speak about it. Eli?
Thanks, Terry. And thanks, Michael. So you guys both touched a bit on how the visual playback has been used as a part of your defense and your compliance strategy. I'll finish up here to close the loop and just give a little more detail on how the technology actually works. As I mentioned before, so over the past 3 years, our TCPA solution has really become an industry standard for proving TCPA consent. There are now over 400 companies using our technology across more than 20,000 different websites, and we're witnessing over 150 million consumer events every month. So what that actually means is we have a piece of code that gets implemented directly on a website page that a consumer visits and enters information. So earlier when you heard Michael talking about the lead generation firms he works with, there are consumers visiting websites, entering their name, their email address, their phone number into forms and requesting to be contacted on hundreds of different websites across the web. And on each of those sites, Lead ID technology lives in the background, and we're able to witness everything that the